4 ways to pass along bank accounts to your kids, and also what happens to these bank accounts while you're alive. My name is Michael Pevney, and I am an estate planning lawyer in California. I create estate plans for California families. If you've got any questions about estate planning or anything relating to estate planning, you can ask them in the comments, and you can also go to my website. And if you live in California, you can set up a time to talk with me for free by going to my website, ocestateplanlawyer.com. The link should be below. So these are the 4 ways to pass on bank or other financial accounts to your kids. I'm going to sort of go in order of generally worst to best. The final one, the 4th one that I talk about, is generally what I recommend my clients do. So the first thing that you can do is have a joint account, a joint bank account, where you're on the account as well as as well as a child. So let's see, say I have me and I've got 2 daughters. Let's just say one of my daughters is on this bank account with me. What that means is that child becomes an equal owner to that account. They can deposit money into it, they can withdraw money to it, they can manage any of this money at any time. The good thing about it is that they can manage my account if I'm incapacitated or if it is just inconvenient for me to do my own banking, whether that is because of a healthcare problem or not. What happens though when I pass away is this account simply belongs to that child. They get to do whatever they want with that account. It belongs to them with no strings attached. If this is in investments, we need to be a little bit concerned about potential capital gains tax issues, and especially if you have more than one child. Only having one child as a joint account holder can maybe present some fairness issues if you want things left equally to all of your kids after you pass away, because it only belongs legally, and they can do whatever they want with it, to the one child that is the account holder. And another drawback to this is the money is equally theirs. So if a child is sued, or a child is going through a divorce, or a child is going through a bankruptcy, those assets are at risk, even if this is your main account that you use to pay bills, or if it's a savings account where you're stocking up money for emergencies or for whatever reason that you want. It is open to that child's creditors because you are joint owners. You each have full and equal access to that account while you are alive. And again, potential issues if there are other siblings, it could create a little bit of strife, a little bit of family drama, so that's something that we want to be concerned about. The second way for a child to have access to your account while your funds might not be at risk for their creditors is to make a child a power of attorney. Now, a power of attorney is a document that's created that gives somebody else access to your accounts without them being open to use it legally for themselves. Everything has to be used for your benefit, the person who creates the power of attorney. So I give my child a power of attorney over my bank accounts. That means that they can go into the bank, they can present them this document, this power of attorney document, basically saying that whatever powers I grant them to use this money, they can do that. And as long as the bank accepts that, and we usually need to make sure that this document is either witnessed or notarized. Typically, a notarization is important. It can help a parent with finances while I am alive and mentally competent, or in the case of a durable power of attorney, once I am mentally incapacitated but still alive, it can help them access those accounts. The main point of a power of attorney is that the power of attorney, my child in this case, must act as a fiduciary, meaning they owe a duty of care and a duty of loyalty to the person whose account it is. The money has to basically be spent for my own benefit. If they go beyond that, using it for themselves, taking it, that's basically where we get into the fraud area. So that can be helpful either just for convenience purposes or if I am mentally incapacitated. What happens to a power of attorney, though, after I pass away is the power of attorney ends. It completely ends, and that child no longer has access to my accounts, and depending on if there's a beneficiary named on that account, it may or may not have to go through the court probate process and have to follow the terms of a will, if I have a will, if a trust is a beneficiary of that account, and if not, we have to follow the rules of the state that you live in about what happens to things when people pass away. So a power of attorney can be beneficial, especially if for a matter of convenience or if somebody has long-term illness or incapacity, and it is not open to the creditors, anybody that has a lawsuit against or a legal judgment against or a bankruptcy or a divorce type situation of that power of attorney, because it's not their money. It's still my money, but they're allowed to spend it on me. But it does not help in any way to determine who inherits that account after I pass away. The third way for kids to manage bank accounts for kids is a beneficiary, what's sometimes known as a POD, payable on death, or a TOD, transfer on death designation. Essentially what that means is once I pass away, this account belongs to whoever I make that beneficiary. And that account does not belong to them while I am alive, and it is relatively easy. It should be easy for them to gain access to the account once I've passed away, but it's only once I've passed away. They don't get access to it while I am alive, whether I am mentally competent or not, or incapacitated or in a coma. It only happens upon death. And essentially what happens is the child goes to that bank. They have to show some sort of proof that I've passed away, usually in the form of a death certificate, and their ID, who they are, and if they are that beneficiary, then they shortly thereafter get complete control of the account. They get it directly, they get it in relatively short order, almost immediately, with that death certificate and with their own ID. So that's great, because the positives to that are that it avoids the probate system, meaning that it should not have to go through court. It does not have to be approved of by a judge. It's basically between me when I'm alive and the bank, because I've said that when I pass away, I want this money to go to this child. Now, if there's more than one child, typically a bank's going to let us set up things in percentages or fractions. If I have 3 kids, I can leave a third to each of them, and so things can be done on an equal basis. But that has to be clearly stated. We often don't want to necessarily make one child that POD or TOD beneficiary and just trust them to equally distribute things. Because when people pass away, even if kids get along, in my experience, there can be some conflict. So we want to make things very clear. We want to make sure that it is clearly stated. And of course, what it doesn't give is the capacity and the ability to have control over that to our beneficiary while I'm alive. So it can't benefit me while I'm alive. They don't have access to anything, whatever my health condition is. If I'm medically incapacitated or in a coma or something like that, it does not give them the power to use, or even for my own benefit, that account. So that's really what the power of attorney document is for. And then the fourth, and really the most complete way to handle things, is to place that account inside of a trust, a revocable living trust. Now, the trust means that the trust owns that account, but typically in a living trust, if I'm the person that set it up, I have complete control over that trust, and things can only happen with my say-so. But within that trust are certain terms that are written, like who gets control over things if I am medically incapacitated. So the next trustee, even though I'm still alive, I remain the beneficiary of that trust, and usually that involves showing some sort of a doctor's note or medical information to the bank, and that can give a child or children control over that account as the new trustee while I'm still alive, and in that way it can sort of act like a power of attorney. And once I pass away, the next trustee, it's often going to be the same person that's the trustee for purposes of medical incapacity. Then, once I'm gone, I'm no longer the beneficiary. I created the trust, but I'm gone. So now we have new beneficiaries, and the trustee, the new trustee on that trust, is going to be required to do what the trust says. So if I have one child acting as my trustee after I pass away, the new beneficiaries are all 3 children, even though this trust still exists and the property is inside and the money is inside of an account owned by that trust. The new trustee is required to distribute things equally to those beneficiaries, or frankly do whatever I have said in the trust with that account. And there's also a lot of controls on the way that things can be distributed. So for example, if I have younger kids and I don't necessarily want them to have control of that money, their share of things, until they reach a certain age, 25, 30, 40, or even older than that, that gives some protection from any creditors or lawsuits, that sort of thing, of that child, of that beneficiary. And of course, another benefit is it can help manage incapacity, and it keeps things private as well. It's going to completely avoid the entire court probate process, which means that it is not open to prying eyes, and things are distributed relatively quickly, much quicker than the probate system. Where I practice in California, the probate system can often take a year or 2 and ultimately involve a judge's order for the bank to release those funds, whereas if things are in a trust, that can be avoided. So those are really the 4 ways that things can be, how your bank accounts can be managed while you're alive and distributed to the people that you want once you pass away. So we can always put a kid on the account, making it a joint account. That means that they own the account as well. And we've talked about the good things and the bad things about that. Second, we can have a child act as a power of attorney for us. That only is in effect while we're alive. Third, we can make a beneficiary a pay-on-death beneficiary, a child or children, and that only, of course, takes effect once we pass away. And then fourth, we can place that account inside of a trust, typically a revocable living trust. That's the type of trust that I usually create for my clients, and that sort of gives us the best qualities of the prior things that I mentioned. People get to control things for us if we're not able to while we're alive, and then things have to be distributed to the people that we want once we are gone. So I appreciate your time and your attention. Once again, my name is Michael Pevney. I'm an estate planning lawyer. I practice all over the state of California. So if you want to set an appointment to speak with me for free and you live in California, you can set up a time to do that by going to my website, which should be in the description, ocestateplanlawyer.com. Thanks for your time.